moving to Senator Leding. Senator Leding, please identify yourself for the record and tell us which bill you're referencing today.
The very tired Senator Greg Leding from District 30 in Fayetteville. I have three. We're going to start with Senate Bill 458, and there is an amendment for this bill.
Okay, 458. Senator Gilmore is recognized.
Just a point of privilege, I'd like to remind the good Senator Leding that he's done enough. He can stop running bills.
Noted. Thank you, sir.
All right, while the amendment is being passed out, would your guest please identify herself for the record as well?
Thank you, Mr. Chair. Emily Virgin, Director of Advocacy and Government Relations at Human Rights for Kids.
Thank you, Ms. Virgin.
And the amendment, I can just explain that very quickly, just incorporating some feedback that we got from this committee, from the prosecutors, and from Judge Braswell, who spoke on this bill. Essentially, we struck a lot of the legislative findings from the front. We took out the mandatory minimum part that I know was a concern for many of you, and I specifically remember Senator McKee having concerns over that issue, and incorporated, like I said, some language that Judge Braswell recommended, and that is the amendment.
Thank you. We have a motion from Senator Dees to adopt the amendment. Do I see a second? Second from Senator Stubblefield. All in favor of adoption of the amendment, signal by saying aye. Opposed, like sign. All right, you are, it is passed. The amendment has been adopted. Please proceed with Senate Bill 458 as amended.
Sure, and won't spend too much time since we did spend quite a few minutes talking about this bill last week. Essentially what we're doing is just trying to make sure that when a minor is being sentenced that we are considering certain factors from their childhood, including traumatic experiences. We understand that this is usually the practice in juvenile courts, but it's not always the case that adult court judges do this kind of thing. And with that, I will let Ms. Virgin say a few things.
Yeah, thank you, Mr. Chair, members. So in the last committee meeting, I think there was some discussion about whether this evidence is already being considered at transfer hearings. And what we heard was that generally, yes, if that hearing is being conducted in the juvenile court judges are pretty well trained on these things and are considering them. However, what we have learned in speaking with the juvenile ombudsman in particular is that in cases where she's called to testify in transfer hearings, the vast majority of those are taking place in adult courts. And so those judges are not as well trained or as well experienced in the backgrounds of juveniles. And so what this would do is require that those judges have that consideration as well. And something else that I think would be of note to the committee is that attorneys also look at these statutes, defense attorneys, in preparing for a hearing and having this language specifically that they must consider, they should present evidence if it's available on trauma, on adverse childhood experiences, and on evidence of the child's status as a victim of trafficking or abuse. That gives defense attorneys a roadmap to be able to know what a judge must consider. And so what we're doing is not only providing that roadmap for attorneys, but also ensuring that this evidence is considered whether you're at a juvenile court or whether you're in an adult court. And so I'd be happy to take any questions.
This is probably a naive question for myself, but when a case is decided to go to, you said some judges have more experience in juvenile cases and some more adult. What's the signal of sending a case to which judge? Is it by age of the defendant, or is it clear cut? Will you help me understand that? So
when you're dealing with a case that is up for transfer, so a child, essentially it's a decision of whether a child should be in juvenile court or whether they should be in adult court. There is nothing that says which court they should consider which court is appropriate. Sorry, I'm also tired and hungry. So my brain may not be working as well as it should. But so what you have is that there isn't a whole lot of consistency when it comes to where this transfer hearing is taking place and what kinds of judges are considering it. So you could be in juvenile or adult court considering whether a child should be tried as an adult.
Thank you. Members, any questions? Seeing none, we do have, I believe, potentially two people signed up to speak against the bill. The first is a Tom Tatum. This is from the previous bill sign up. Is Tom here? Okay, thank you, sir. So there was no one else. Did I miss anybody on the list? Okay. We also have Mr. Paul Calvert.
That's a different bill.
Oh, I'm sorry. Sorry, wrong bill. Excuse me. All right. Anybody else in the room? I'm not seeing any. Okay. All right, Senator Leding, you're free to close for your bill.
I'm closed and would ask for a good vote.
Okay. Members, I've got a motion from Senator Gilmore as amended. A motion to pass as amended from Senator Gilmore. Do I hear a second? Second from Senator Stubblefield. All in favor to pass Senate Bill 458 as amended, signal by saying aye. Opposed, like sign. All right, congratulations, Senate Bill 458 as amended has passed.
Thank you. Senate Bill 595.
Yes, sir. Okay, we've got an amendment on Senate Bill 595 that's being passed out as well.
Yes.
Do you ever get a house sponsor?
These amendments add the House sponsors, yes.
All right, that amendment is being passed out.
Sure, and I can describe the amendment briefly. This adds a House sponsor, Senator Johnson. It also incorporates feedback that we got from Senator McKee while we were vetting this bill and some feedback that we got from the prosecutors.
Thank you, Senator Leding. You've heard the description of the amendment. Do I see a motion to adopt the amendment? I see a motion from Senator Rice, a second from Senator Tucker. All in favor to adopt the amendment, signal by saying aye. Opposed, like sign. Congratulations, the amendment has been adopted. You are free to present the bill as amended.
All right, thank you, Mr. Vice Chair. This is a little bit more straightforward. All we're saying here is that if a minor is going to be interrogated by law enforcement, they should at least have a parent or guardian with them in the room. We incorporated some feedback from Senator McKee, who wanted to make sure that if the parent is also perhaps a suspect in whatever it is that the child is being questioned over, that is taken into consideration. And then also incorporated some feedback from the prosecutors who said, what if they can't make contact with a parent or guardian? And so we've just said that they need to make a reasonable attempt to contact them. Speaking with the vice chair earlier, asked why we wouldn't have the minor be required to have an attorney with them. We actually tried that 4 years ago and was not able to get that passed. But we do feel with all the work that we're doing to empower parents, the least we can do is make sure that a child has a parent or guardian with them while they're being interrogated. And with that, I'll let Ms. Virgin speak.
Thank you, Senator Leding, and thank you, Mr. Chair. Members, Senator Leding has explained this very well. This really is about ensuring that when a child is being interrogated by law enforcement, no matter what the offense is, that they speak with a parent or legal guardian before they waive their rights, before they can be interrogated by law enforcement. We feel this is important for a number of reasons. Number one, I think it is common sense that a parent would want to actually consult with their child, have some contact with their child before they are interrogated by law enforcement. We know that this is important for a number of reasons, and I think incumbent upon this committee is to make sure that there is integrity in these interrogations. And so to ensure that children understand the gravity of the situation, that they understand the seriousness of the situation, that they understand the consequences of waiving their Miranda rights and speaking to law enforcement, those are all very important things to ensure the integrity of law enforcement interrogations and to prevent false confessions. I won't belabor the point or give you all of the numbers, but we know that children are at a much higher risk of falsely confessing to something. We have seen that time and time again. Children just don't understand sometimes. They think if they tell law enforcement what they want to hear, then they'll get to go home. That's not the case, but that is something that a child in this situation might believe. And so for them to just have this simple consultation with their parent, it can take place via phone, video conference, or in person. And then the exceptions that we've built in, number one, if the parent is a co-defendant. Number two, if the parent is unavailable and law enforcement has made an effort to contact them. And then also there's an exception for if the the parent has harmed the child. So if they've been convicted of, if they've been accused of, or if they are being investigated for some sort of crime against the child and wouldn't necessarily have the child's best interest at heart, then that would be provided for as an exception. We tried to incorporate all the feedback that we've received on this to cover all of those situations where this might not be reasonable or protective of the child. And I will say that current law in the juvenile code says that a parent must be notified that their child has been taken into custody, but there's currently no requirement that the parent and the child actually consult with one another.
Thank you for the description of the bill. Members, do we have questions? Seeing none, we do have some folks signed up for and against, I believe, here. We've got Mr. Brian Sexton. Oh, okay. Free to come to the table. And we also have a Will Johnson. Is that? Sorry, Will Jones, excuse me. Please identify yourself for the record. And you are, we do have a 3-minute testimony. Is this a one testimony or separate, just for our timing records? Need to make sure we're clear on that.
We're going to try to make it one testimony the best we can. And I'm
Understood.
David Etheridge. I'm the elected prosecutor from the 14th Judicial District.
Brian Sexton, elected prosecutor, Benton County, 19th Judicial District West.
Will Jones, elected prosecutor for Pulaski and Perry County, right here in Little Rock.
Thank you. You gentlemen are recognized in 3 minutes for testimony. Thank you.
We are against the recommended changes for a number of reasons. The first and foremost is we believe that the juvenile code covers these particular provisions quite well. Not every juvenile is juvenile. At some point, a prosecutor has to make a determination based on the history of a child, based on what officers can determine for their investigations, that they're not living as a juvenile, they're living as an adult. And that usually, with the consideration of the seriousness of the charge, triggers the prosecutor's obligation to consider an adult case. That said, that's not set in stone. A juvenile can ask for a transfer hearing, and all of those factors are built into the transfer hearing to make a determination on whether the juvenile understands what's going on. I believe that has already been set forth by the legislature. It does its job, and these changes are not needed. I'll defer to my colleagues.
Thank you, Mr. Chair. I'll be brief. We, obviously, I'm the prosecutor in Little Rock, and I can safely say it's the most violent county in the state. We've got currently right now, just looking at our numbers from this morning when I knew this was going to run, we've got 52 juveniles right now in our jurisdiction charged as adult for very serious crimes, murders, shootings, batteries, terroristic acts, all kinds of things like that. And what we have happened, in fact, we've had four capital murders have been committed by juveniles since the first of the year, 1st of January. So what we run into is we have violent adults that want to have juveniles carry out their violent acts. And we see that. And it's a term that the people that I work with in our community, they call them crash test dummies. They literally get juveniles to go commit their offenses because they know they won't face the same amount of time as others. And so now this would be a situation where you say, you go carry out this execution that I want done, and just make sure that we don't have your parents around, and make sure that then you don't even have to talk about it as an adult if you are caught and questioned by police. And I just don't want to put children in that situation. And as Mr. Sexton said, the case law right now covers that. If it is a case that is prosecuted in juvenile court, you have to have juvenile Miranda, which has the parents and all that. If it's a case that we make the decision to charge someone and it stays in adult court, then they are treated as an adult.
Thank you. Members, any questions for the prosecutors? All right, seeing none, thank you for your testimony today. That's helpful for me. I think that was one of my questions about which court, and it sounds like that's some definitional examples there, so thank you. All right, any further questions? Seeing none, Senator Leding, you are free to close for your bill.
Certainly appreciate those comments, but still feel that if our child is being interrogated, we would absolutely want to make sure that we were there with them during that process. And with that, we are closed.
Thank you, Senator Leding. What's the will of the committee? I see a motion to pass from Senator Tucker as amended. I do not see a second. Without a second, I'm sorry that the bill has failed.
Yep.
Thank you,
Thank you,
Senator
committee. And just one more that would also be very brief.
Yes, sir. Next bill.
This would be Senate Bill 549. And if Mr. Calvert would like